then, whether he should have been warned or what. I'm in the same position as him. He's basically asking this court to come up with an answer to the objection that he's raising. He's basically saying to this court, my lord, this witness has made a section 204 statement. I don't even know whether he made that statement. I don't even know whether that statement will be relevant in me meeting that witness, my lord. But the state is saying to the court, my lord, this witness made a section 204. And having made that section 204, I don't know if the defense is allowed to lead him without having warned him of the provisions of section 204. I've called a witness, my lord. The defense does not investigate on the basis that a witness is section 204. No. The defense simply calls a witness that they would, which in their mind are saying that this witness will come and assist this court in the presentation of the defense case. Whether that is a section 204 witness, whether it is a section 2 or whatever witness. Now the question is, if this was a section 204 witness, why did the state not call him? For them to come and complain thereafter that, but no, the defense cannot call this witness because he was our witness in terms of section 204. Then they should have called him. They decided not to call him. And then you are saying, oh, that which we decided to throw away, I think it will be useful for us. Then we went to the trash place, we cleaned that witness with all the soaps and everything and said, now we are going to make you a human being. Come and testify, come and tell this court, what is it that you know about this incident? Then the state stands up and says, no, but we should have warned him. No, the defense does not call a witness on the basis that that witness is a section 204. That's a prerogative of the state, my lord. But if they decide not to use him and discard him, we'll definitely pick him up from the trash place and come and bring him here to court to come and tell this court what is it that he knows about in this case. So I find no reason for the state.
Yeah, but you guys are not addressing me in terms of the law. It's okay to talk and talk and talk and talk.
But that is the state that must do that, man.
Mr. Baloi, I'm saying this witness is impeachable.
Well,
that's the legal language we are addressing me on, not.
Yes, Malat, we're raising issues of procedure. There's section 203 and section 204, and that refers to the rights of a witness. And I think every witness needs to be apprised of such rights. It's not dependent on the witness. It's a question of procedure. Counsel has been asking a witness, for instance, whether Constable Zungu gave him a firearm, to keep it for him. I think this witness needs to know what his rights are as far as incriminating questions are concerned. And secondly, as we mentioned, my lord, that this witness doesn't just come as an ordinary witness. There's a certain status that is accorded to him, and that needs to come on record, my lord, that what type of witness he is. But regarding the first point that we raised, my lord, we differ from Advocate Nisi with the greatest of respect. It's crucial. If he's approaching the evidence from a wrong perspective, then that goes to the heart of this witness evidence. If the evidence of Brigadier Gininda is, as we say, that his statement was obtained first, and that they learned from his statement of the involvement, of the presence of Constable Zungu, that's crucial, man. It goes to the heart of this witness evidence. It goes to his credibility. He's been saying that Constable Zungu is lying all the way, but if his evidence is approached from the correct perspective, as testified to on record, approach to the witness. That's all they were saying on that. And Advocate Mrs. says the sequence is not crucial. It is crucial because it goes to the credibility, it goes to the way that his evidence should be approached. And Margaret has just referred me to the evidence of Brigadier Gininda on the 1st of November 2024, page 25, line 2 to 9, where he says, "There are statements that are obtained. I'm just not sure if those witnesses have testified, but during the course of the investigation, before Constable Zungu's statement was obtained, there were statements obtained which linked all the accused in this offense collectively from accused 1 to 5. And those statements are in the
Mr.
Is it the court, Madam?
Yeah.
May I request an indulgence just to say a thing or two in clarification and demystifying what is happening here. I will not repeat the first point relating to how the investigation was conducted. This court is not concerned about what processes, actually let me not say, this court is not concerned about what processes. Whether A came before B or C came before A with regard to the testimony that is here at court, my lord, that is immaterial. What is immaterial here at court is whether the allegations that are raised against these accused persons have got any substance. Whether in the course of investigation the state jumped from 1 to 7, from 7 to 14, that is immaterial. All that is material is the presentation that is made here at court. Now,
No, I differ with you. Let me tell you. The sequence of the occurrence
yes,
is critical
yes, ma'am.
because when you take a witness under cross-examination
Yes, ma'am.
and he starts testifying about the death of Rata Mukhashi
Yes, ma'am.
without having testified how Rata was stabbed with a knife, a panga, his head was shaved off, etc., etc., etc. The judge is going to say to you, how did the assault start?
Yes,
Yeah.
yes.
So it's material. Other counsel will argue that this witness is not reliable because he says B instead of starting at A. I don't want to put it further than that.
Yes, ma'am.
Yeah. So the sequence of the evidence is material.
That is so.
Must be so.
I definitely
The
agree.
only thing
Yes.
which you guys must tell me, why don't you read 204? Because, for instance, look at section 105A, where a person wants to plead guilty and he conducts a consultation with the state and subsequently decides not to sign the agreement. That act of not signing that agreement nullifies that agreement. Is that not so, Mr. Baloi?
yes, indeed.
Right. Now, if a person is a 204 witness, are you saying to me there's no procedure whatsoever which is necessary to warn, as Mr. Baloi says, the witness of his rights?
I'm just
Because
about...
in terms of section 203,
Excuse me.